Article 16 Equality of Opportunity Matters of Public Employment as a corollary from the general assurance of the absence of discrimination by the state of ground only the religious, race, caste, sex, place of birth. Article 15 the Constitution guarantees equality of opportunity in matters of public employment. Article 16 says that there shall be equality of opportunity for all citizens in matter relating to employment or a appointment or any office under the state. No citizen shall on ground only religion, race, caste, sex, descent, place, birth, resident, any of the ineligible for or discriminate against the respect of any employment of office under the state. The nothing in the article shall prevent Parliament from the making any law prescribing in regard to a class or classes of employment or appointment for to a under office under the government or any local or other authority within the state of union territory any requirement as the residence within the state or union territory prior to such the employment or appointment. Nothing in the article shall prevent the state for the making any provision for the reservation of appointment of post in favor of backward class citizen which is the opinion of the state. It is not adequately represented in the services under the state. Nothing in the article shall prevent the state from making any provision for reservation in matter of promotion, consequential seniority to any class or classes of post in the services under the state of favor of scheduled caste and scheduled tribes, which is the opinion of the state, are not adequately represented in the service under the state. Nothing in the article shall prevent the state of considering any unfilled vacancies for a year which are reserved for the field in up to year of accordance with the provision for reservation made under clause 4 or clause 4a as a separate class of vacancies to be filled up any succeeding year for years, and such classes of vacancies shall not be considered together with the vacancies for a year in which they are being filled up, determining the ceiling of 50% reservation on the total number of vacancies of that year. Nothing in the article shall affect the operation of any law which provides that the incumbent of an office in the connection with the affairs of any religious or denominational, institutional, or any other member of governing body thereof shall be a person professing a particular religion belonging to a particular denomination. The Constitution 103rd Amendment Act 2019 2019 has amended Article 16 of the Constitution is added to new clause 6 for provide for reservation of appointment or post favor of the economically weaker section of citizen in addition of the existing reservation of subject to maximum 10% of the post of each category. Clause 6. Article 16 provide as follows. Nothing in the article shall prevent in the state of making any provision for the reservation of appointment post of favor of any economically weaker section citizen other than the classes mentioned in the clause 4. The addition to the existing reservation is the subject to the maximum 10% of the post in each category. The expression of matter relating to employment or appointment contained in Article 16 first includes all matter in relation to employment both prior and subsequent of the employment which is the incidental to the employment and form part of terms of condition of such employment. The principle of merit cum seniority puts greater emphasis on the merit and ability, and where the promotion is governed by the principle of seniority plays a less significant role. However, seniority is to be given weightage for when merit and ability more or less are equal among the candidates who are in the promoted. The finally seniority list once published cannot to be disturbed as the behest of person who choose not to challenge it for years. Its sanctity must be maintained unless there are very compelling reason to do so in order to do substantial justice. Determination of seniority is a vital aspect in the service career of an employee. It must be based on same principle which are just and fair. This is a mandate of the Article 16 of the Constitution. The true import of equality of opportunity is not simply a matter of legal equality. It is existence depend not merely on absence of disabilities but on the presence of abilities and opportunity of excellence of each cadre and grade. As equality of opportunity means equality as between the member of same class of employees and not between that the separate independent classes. All persons similarly situated should be treated similarly. All persons similarly situated should be treated similarly. Only because one person has approached the court, that would not mean the person similarly situated should be treated differently. When a regular vacancies in post are to be filled up, a regular process of recruitment or appointment has to be resorted to as per the constitutional scheme, as and cannot be done in a haphazard manner based on patronage or other consideration. Hence, the appointment, recruitment of temporarily contractual, casual, daily wage, or ad hoc employment dehors. The constitutional schemes cannot be regularized. Such appointee cannot claim to be made permanent. Ad hoc appointment is always ad hoc appointment about the constitutional scheme cannot be regularized. Such appointees cannot claim to be made permanent. An ad hoc appointment is always to a post but not to the cadre services, and also not made in accordance with the provision contained in the recruitment rules for the regularized appointment. In ad hoc appointment is not entitled to a family pension only because the services of ad hoc employee continued. The continuation of ad hoc employee would not mean that their hereby this status has been changed. An ad hoc employee does not hold status of a government servant like other employer. The government is also entitled to pick and choose from amongst as a large number of candidates offering themselves for employment. But this can be done. This can be done on the condition that all the applicants must be given an equal opportunity along with the others who qualify for the same post. The selection of test must not be arbitrary, and technical qualification and standards should be prescribed where the necessary. A person cannot be excluded from state services merely because he is a Brahmin, even though this result is by reason of distribution of post amongst communities according to a ratio or quota. Government job or services cannot be denied to a person suffering from AIDS. This is equality is to be observed by the state, not only the matter of appointment to the public services, but also a matter of any other public appointment where the relationship of master and servant exist between the state and employee. It is bar discrimination not only the matter of initial appointment but also the promotion and termination of the services itself, as employment includes promotion. This rights a safeguard not only against the communal discrimination but also against local discrimination or even against the discrimination against the weaker sex. The right of consideration for promotion of departmental promotion committee is a fundamental right guaranteed under Article 16, provided a person eligible and its zone of consideration, but the consideration must be fair according established principle of governing services jurisprudence. This only exception to the above rule of equality are residence within the state may be laid down the parliament as a condition for a particular classes of employment of appointment under any state or any other local authority. Article 16(3). By virtue of our parliament enacted to public employment requirement as a Residence Act 1957, empowering the government of India to be prescribe resident as a condition for the employment to certain post of services in the state of Andhra Pradesh and in the Union Territory of Himachal Pradesh, Manipur, Tripura, now states. Act having expired 1974, there is no provision of prescribed residence as a condition of public employment except that the Andhra Pradesh special provision have been made to inserting a new Article 3371D post in the Constitution itself. The state may reserve any post or appointment in favor of any backward class of citizen who is the opinion of the state are not adequately represented in the services under the state Article 16(4) and the provide socio-economic equality to the disadvantage. The expression of backward class of citizen contained the Article 16(4) would be scheduled caste and scheduled tribe within the purview offices connected with a religious or the denominated institute may be preserved for a member of professing the particular religion or belonging to the particular denomination to the institution relate Article 16.5. The claim of member of the scheduled caste and scheduled tribe shall be taken into consideration in the matter of appointment to services and maintenance of efficiency of the administration. Article 3335 335, but the proviso to Article 335 provided for the giving relaxation is qualifying marks in any examination or lowering the standard of evaluation in favor of member of SC/ST hits the consideration of maintenance efficiency in administration has done away emphasis on the laid down by the apex court the same cases. Supreme Court has held that while Article 16.4 is apparently without any limitation upon the power of reservation conferred by it, it has been read together with the Article 335 which enjoy that is taking into consideration the claim of member of the scheduled caste and scheduled tribes making appointment of connection with the affair of union or state, any policy of the state that was consistent with maintenance of efficiency of administration. The result that there can be no doubt the constitution maker assumed that the while making adequate reservation Article 16.4 care would be taken not to provide the unreasonable, excessive or extravagant reservation. Therefore, the special provision properly made under the Article 15.4 reservation made under Article 64 beyond the permissible legitimate limit would be liable challenge as the fraud on the Constitution. However, the Constitution 82 Second Amendment Act 2000 inserted a proviso to Article 335, almost closing the door of consideration of maintenance of the efficiency of administration in the making of appointment in services and post of connection with the affair of union or the state, insomuch as the proviso empowered the state to relax qualifying marks of examination or lower standard evaluation. For reservation is matter the promotion of the member of SC/ST any classes of services or post in connection with the affairs of the union or the state. The concession relating to the reservation would be applicable only when a scheduled caste or scheduled tribe candidate come within the number of available vacancies. It is to be noted carefully that the prohibition against the discrimination in the matter of public employment attract where the discrimination is based only on any of ground enumerated, namely religion, race, caste, sex, descent, places of birth or residence. It does not prevent the state, like other employment, to pick and choose from a member of candidate, either for appointment or the promotion on the ground of efficiency, discipline and like. It is also to be noted, though the reservation in favor of backward classes is permissible under clause 4 Article 16. So, no such reservation is possible in favor of women, nor any discrimination in favor of women possible. Easy relaxation of rules of recruitment or standard of qualification or like. The court tribunal can neither prescribe in the qualification nor upon the power of the concerned authority so long as the qualification prescribed by the employer is reasonably relevant or in the rational nexus with the function with duties attached to the post and are not violative any provision of constitution, statute and rules. The court cannot interfere with the method of reservation unless there is some clear illegality. Nor the furtherance of social equality. Constitution provide for the abolition of evil of untouchability, see Article 17 and the prohibition of conferring title by the state. The Mandal Commission case. A 9-judge bench of Supreme Court has in Indira Sahani case, popularly known the Mandal Commission case, laid down by the following important point which summarized in law on the issue of reservation government of employment. The further discussion the author Salter Constitution 14th edition 2008 under Article 16.4. The Article 16.4 exhaustive of the provision that the made in favor of backward classes in the matter of employment Backward classes of citizen is not defined in the constitution there and the integral connection between the caste, occupation, poverty and social backwardness. In the Indian constitution, lower caste are treated as backward. A caste may be itself constitute a class. The backward classes can be identified in a Hindu society with the reference to caste along with other criteria such as the traditional occupation, poverty, place of residence, lack of education, etc. and the communities where the caste is not recognized, there the rest of criteria would apply. The backward contemplated by Article 16 for mainly social, it need not be both social and educational means test, signifying imposition and the income limit for the purpose of excluding person from the backward classes. Those who income above that limit are referred to the creamy layer. Income or extended of poverty can be taken a major social advancement on the basis of creamy layer of a given caste can be excluded. For the getting reservation, a class must be backward and should not be adequately represented in the services under the state. The reservation contemplated in Article 16 for not be exceed 15%. 50%. The rule of 50% should be applied to each year. It cannot be related to the total strength of class, services and cadre activities. Reservation of post under Article 16 for confined the initial appointment only and cannot extend providing reservation in the metro promotion. If a reservation in promotion exists in all continue for 5 years, 16 November 1997 by the Constitution 77th Amendment Act 1995, the limitation of time has been removed by inserting clause 4A enable to the continued reservation in the promotion for SC/ST. Identification of backward classes is subject to judicial review. Subdivision of other backward classes contemplated in the Mandal Commission case not applicable scheduled caste or scheduled tribe. Hence, sub-classification of sub-grouping SC/ST is not permitted. Article 16 for enabling provision of confer the discretionary power on the state make reservation if required, but is confirm no constitutional right upon the member of backward classes to claim reservation. The vacancies reserved should be carried forward for a maximum period of 3 years if candidates from the backward classes were not available, after which they were lapsed. By inserting Clause 4B, Article 16 of Constitution 81st Amendment Act 2000, the state has been empowered to consider such the fulfill vacancies as a separate class to fill up the succeeding year or years. However, the Honorable Court put a certain limitation power of the available of the state Article 16 4A and 4B and the same are ceiling limit of a maximum 50% reservation, quantitative limitation, the principle of creamy layer, qualitative exclude, and the compelling reason for the exercise of power under, namely backward class and inadequacy representation and overall administration efficiency as required by Article 335. Thank you.